Welcome to the DeWitt Law Review on WDBO 107.3 FM and 580 AM, Orlando's news and talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW, or visit DeWittLaw.com. If you want to get your legal questions answered on this show, you can send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We are here every Sunday morning at 10 a.m. talking about Florida's legal issues and how they affect you. I'm Josh Fowler in for John Bustecker today, and across from me is attorney Mo DeWitt of the DeWitt Law Firm. Good morning, Mo.
Good morning. How are you doing, Josh?
I am peachy, wide awake, had my coffee already, feeling good. How about you?
Doing well on this lovely Sunday morning. No better place to be.
You look great.
Thank you. I try.
Well rested, some would say. You know, I've heard some rumblings. Something's coming up. I believe it's the JustCallMo.com Comedy Jam. Sounds like a good time.
Yeah, so this is our third year doing it, and it is all for charity. 100% of the money raised, not just the proceeds, but every dollar that we receive is going to the Yellow Brick Road Foundation, which is a great local charity here in town. If you're not familiar with them, then you can look them up at ybrf.org. And basically, they help children who suffer from congenital heart defects as well as their families and try to give them some semblance of normalcy while they're in the hospital. Both of the founders of the charity both had children who passed away from congenital heart defects, which is what led to them starting the charity. So it's a really good cause. They do a lot of good things like... one thing you don't really think of is when you have a small child who's kind of hospital bound or bedridden within the hospital. They have all these tubes and everything. They really can't get out of their beds.
Hard to get around.
Yeah, you can't go anywhere. So they've created these wagons that are approved by the hospitals that have all the stuff to kind of hook up everything they need, so they can at least walk around the hospital or be taking this wagon around the hospital. And just get out of their hospital room and hopefully have a little bit of joy or just, see some different things and things like that. So they do a lot of good things. So the comedy show is to benefit that charity. Again, every dollar raised goes to that charity. And it's going to be on September 15th at Tuffy's in Sanford. We have a bunch of good local comedians. It's going to be a great time. Everybody really enjoyed it last year. If you do want to get tickets are donation based. Starting with a minimum donation, we're asking at $15 per ticket. So you really can't beat that. And you just go to mocomedyjam.com. It's MOE comedyjam.com. And you can get your tickets there. And hopefully we'll see everybody out there. Last year was completely sold out. So if you want to come, get your tickets sooner than later. Yep. But it should be a great time.
I was there last year. It was super fun. Really cool event. Everyone seemed to have a good time.
Yeah, they did.
I believe a pretty decent amount of money was raised for Yellow Brick Road. So that's good all around.
Yeah, that's the important thing.
Yes, sir. Well, you want to dive right into a few questions we have from some listeners?
We can do that. I did want to kind of give people an update on the alimony reform bill. We talked about it a few weeks ago. It has passed now. So it's one of the biggest things in the family law sector of Florida family law that we've probably seen in the last decade or so at least, where permanent alimony has now been eliminated under this alimony reform bill. I know that's that's one thing that a lot of people were pushing for, and obviously some people were against it, but it has now finally passed, which basically means that we're left with all the other types of alimony. So the main one's going to be durational alimony, which is just alimony for a period of time. And then we have temporary alimony and bridge the gap alimony and rehabilitative alimony. But in most cases now, we're going to be calculating the alimony for just a specified period of time rather than permanent alimony, which permanent alimony, even though it does say permanent, is a little bit of a misnomer, because once you do retire, the case law said that you had a right to retire. Now, basically, the statute kind of agrees with the case law and basically says the alimony ends upon this date. So the issue before was you had to file a second action. It was basically a second lawsuit to go back to court to reduce or eliminate the alimony once you reach retirement age. That could be costly. It was a headache.
Yeah.
So this is hopefully to streamline that process.
Yeah, a lot less running around for the people paying that. And was that also that would end if the party receiving the alimony got remarried or made more money or something?
So under the statute, and there are, some people agree to what we call non-modifiable alimony, which basically means it can't be modified for any reason. But under the existing statute and the prior statute, if you get remarried, your alimony is going to terminate. Of course, if the party dies, your alimony is going to terminate, and that's why sometimes there's life insurance to secure those alimony obligations. There's the cohabitation provision, which was slightly modified under the new statute, where basically if you're living with someone in a financially supportive relationship, basically you're living as if you're married, you're just not legally getting married because you want to keep receiving the alimony. That was a basis to move to terminate or reduce the alimony as well.
So no one could kind of skirt the law on that one.
That was the idea, but the problem with cohabitation cases was it was often very difficult to prove that they were in a financially supportive relationship because while they may be living together in a house, it's, again, financially supportive. So you have to look at, all right, are they sharing bank accounts together? What does the financial circumstances look like? And obviously, until you file the lawsuit and dig into it, you really have no idea. So you're just kind of guessing. So those could oftentimes get to be kind of ugly cases because you really had to delve through the other person's finances pretty deeply to see what was really going on there.
Again, a lot of work involved that people don't necessarily want to do.
Yeah. So the other big thing under this new law was they've changed the definition for short-term, moderate-term, and long-term marriages. So, before, short-term marriage was anywhere from 0 to 7 years. Now it's from 0 to 10 years. A moderate-term marriage was 7 to 17 years. Now it's 10 to 20 years. And a long-term marriage was 17 years plus. Now it's 20 years plus. So they've increased those lengths a little bit, and they've also provided some time frames as far as how the length of time that the court can award alimony. So for on a short-term marriage up to 10 years, they can only award it for half the length of the marriage, unless there are kind of extenuating circumstances. Same thing goes for moderate-term marriages, but that's 60% of the length of the marriage. And then on long-term marriages, it's 75% of the length of the marriage. But you still have to factor in, potential retirement dates there based on, what their expected retirement date is, pursuant to Social Security, things like that.
Got it. Well, that's a helpful segue, actually. Speaking of long-term marriages, this person emailed in with a question, wanting to stay anonymous, naturally.
Yeah.
They're wondering what Florida's laws are for being married for 21 years. Obviously, what you just explained, a long-term marriage. They said their house was purchased prior to the marriage, and they would like to stay in the house as well as receive some alimony. They have a child, but he'll be 18 in February, and he's heading to college next year. So, what kind of outcome are they looking at here?
So they're married 20 plus years. So, basically the court's going to look at, you're looking about up to 15 years of alimony, but, 75% of the length of the marriage.
Right.
But we also have to look at, first of all, does the person who you're requesting alimony from have the ability to pay, and do you have a need for alimony? So in order to look at that, we're going to be looking at the financial circumstances of each party. And in a divorce case, you're going to fill out a financial affidavit, and that's where we're going to gather a lot of this information from. So first, we're going to look at, the party asking for alimony's financial affidavit and see what are their expected expenses going to be upon this divorce being finalized. What's their housing going to cost, their electricity going to cost, all of those kinds of expenses. Then we have to look at the person that we're requesting alimony from and see, does that person have the ability to pay all or some of that need? And that's basically what they're going to be requesting for as part of the alimony. Now, there are some new requirements as far as how much of the net incomes and the difference in the net incomes of the parties you can request under the new alimony statute. It doesn't really come into play in most cases, but it could come up depending on the situation. So based on that, then once we figure out what the amount looks like, then you could be looking at up to 15 years. It doesn't mean that the court has to award 15 years. It's just that it may not exceed 15 years or 75% of the marriage.
Right.
They said 20 years, right?
21, yeah.
21 years.
So,
all right, so a little bit
right
longer,
around there.
So, but of course, they're going to look at, okay, what does the person who's paying alimony do for a living? What is their expected retirement date? And things like that. So those are all factors that the court's going to look at as far as the alimony is concerned. Now, with the child's 18. Once they graduate from high school, any obligation for child support is going to terminate. So by the
Right.
time this divorce is filed, that may not really be an issue in your case. But when it comes to the house, they mentioned the house was purchased prior to the marriage.
Correct.
And so, even though it's purchased prior to the marriage, any appreciation in the equity of that home during the marriage and over a 21-year marriage, it's going to appreciate quite a bit, one would think, most likely.
Yeah. Especially in Florida.
Yeah. Yeah. I mean, we've seen what the real estate market's done here over the last couple of decades. It's gone insane.
Little wild.
Yeah. So, even though your name may not be on the deed, your name may not be on the mortgage, you may still be entitled to half of the increase in equity that's occurred over those 21 years of the marriage. And that's what we call the call formula. It's a case from the Florida Supreme Court, KAAA versus KAAA, call versus call. And so you're entitled to one half of that equity increase. So if you guys purchased the home for $100,000, 21 years ago, but now it's worth $600,000, well, there's an increase in equity there of $500,000.
Okay.
And you would be entitled to half of that because everything would be split equally.
So $250 to each party.
Exactly. Now, oftentimes we have to figure out, okay, well, how is that going to get paid, right? So there's a few options there where you can either sell the home. If one party has the ability, they can refinance the home and pay the other party out. But those are the kind of the main options, or the ones that I would recommend. Typically, it's either you sell it and split the proceeds, or one party basically buys the other party out of the home. But remember, when you refinance, you have to refinance for enough, not only basically to purchase pay off the mortgage if there is one, and buy the other party out. So, with assuming there's a lot of equity, and I'm going to make that assumption given that it's been 21 years, it could certainly be a pretty hefty price to have to refinance that home.
Yeah, and then you're basically purchasing the house again at what it costs modern day.
Yeah, exactly. I mean, you're buying out one half of the equity, essentially.
Okay, gotcha. And they said they're looking to stay in the house. They didn't say who had purchased the house prior to marriage. If they're the one that didn't purchase the house prior to marriage, does that complicate things further, or is it still kind of the same, like, I'll refinance and give you your cut and we'll be done with this?
Well, it can go either way. I mean, when we're looking at who's going to stay in the house, we really have to look at it from a financial perspective and what makes financial sense for the parties, because you don't want a situation where you're real estate rich and cash poor. And so oftentimes people get attached to homes for sentimental reasons or personal reasons. That's where their kids grew up. They've lived in the house, for 20 plus years at this point.
Yeah.
So they want to stay there. But when you look at, okay, what's that going to cost me on a monthly basis? Well, sometimes it is cheaper to stay in the house. Other times it may not be. It may be better to get the cash out. So assuming that this person wants to stay in the home, like I said, they're going to have to refinance that home for not only, whatever the mortgage is, but half of the equity, and pay the equity out to the other person as part of the closing, essentially, the refinance process. So, a lot of times people come to us and they want to stay in the home. But a lot of times it just doesn't make financial sense. Now,
right.
In this situation, you have an 18-year-old who's about to go to high school and then graduate high school, and they go off to college. And so it may make sense in this situation to say, all right, we're going to wait to sell the home for a few months until he goes off to college. And then once he goes off to college, we're going to sell it and split the proceeds. Yeah. If you're trying to keep stability for the child, because that's another big reason we hear is, well, I want, everything else is being shaken up in these kids' lives. I'd at least want to make sure they're in the same home and have some familiarity with it. Yeah,
just like one thing.
Yeah. So,
makes sense.
Yeah, so, I mean, that's what you really have to look at. You really need to analyze it from a financial perspective, because I have seen people who want to stay in homes kind of get into financial trouble because they have this home and they have enough money to pay the mortgage on it, but they really can't afford the additional expenses.
Gotcha. Well, good advice. Thank you for your question, Anonymous. Again, if you'd like to get your legal questions answered on this show, you can send those over to askask@DeWittLaw.com. That's ask@DeWittLaw.com. And we're going to take a quick break, but we will be right back with more questions and answers right here on the DeWitt Law Review on WDBO 107.3 FM and 580 AM, Orlando's News and Talk.
We just got this client $25,000. I don't show it to you because it's a giant check. The important thing here is the initial offer was only $2,500. That means we got them 10 times the initial offer. Without an attorney, in my opinion, he would have never gotten this amount. The insurance company's own study shows that when you have an attorney, on average, you get over 3 times more than those who go at it alone. In this case, we got 10 times more. Injured on the go? Just call Mo.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's news and talk. Here on the show, we talk about legal issues in Florida and how they affect you. I'm Josh Fowler, filling in for John Busdecker, and I'm with attorney Mo DeWitt of the DeWitt Law Firm. If you have legal questions, you can send them to ask@dewittlaw.com. That's ASK, ask@dewittlaw.com. You can also call the DeWitt Law Firm at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. And we have quite a few questions sent in, so I guess we can just kind of get into these and we'll go from there. This one comes to us from Kathy from Tarpon Springs. She says, "Hello, I've got a bit of a problem. A large tree from my neighbor's yard fell during a storm last week and smashed into my garage. My neighbor is refusing to cover the damages, claiming it's a, quote, act of God. What can I do to get reimbursed?"
Well, I hate to say it, but typically your neighbor is going to be correct on this one. So in most cases, if a tree falls over onto your property from a storm or something like that and lands on your house or your roof or the garage in this case, it is going to be handled by your insurance. Now, there is one sort of exception to that, and that would be if the tree was dying or rotting out essentially, and they knew about it and they just negligently failed to remove the tree from their property.
So if they had a responsibility to get rid of it before, hurricane season comes around.
Exactly. And so, it can be difficult to prove that sometimes, but obviously if you've sent over an email or a text message to the neighbor before and said, hey, this tree is not looking too good, you want to remove it, or I'll help you pay to remove it, or whatever it may be, and they refuse to do it, then there may be a claim that they should have to pay for all of the damage that occurred, or it should go through their insurance. But obviously, you want to let your homeowner's insurance company know about this. There's probably going to be a fairly decent-sized deductible nowadays, depending on your policy.
Yeah.
But if it just truly happened during a storm and it was a healthy tree that came down, I mean, we obviously see this a lot during hurricanes and hurricane season here, then yeah, you are going to have to go through your own homeowner's insurance policy and handle it that way.
So moral of the story is to look for the dying trees in your neighborhood and email those neighbors ahead of time.
You could do that, and also to be a responsible neighbor, if you do have a dead or dying tree on your property, you should have that removed. Now, sometimes, I know in a neighborhood I used to live in, we had a situation where there were dead and dying trees, and the neighbors tried to remove them, but the city wouldn't let them because the city said that they were on their property, even though they were partially on the homeowner's property.
Gotcha.
The trunk was kind of half and half. And so the city actually had to remove them. And I know in one situation, there was a tree that fell on someone's home there, and they ended up suing the city because the city was on notice that this tree it was basically dead, and they had been trying to get it removed for a long time, and they just would not remove it. So, if you do have a dead or dying tree on your property, make sure you're taking care of it.
Guess I have to make a call when I leave here.
Get the chainsaw out.
I'm going to have to do that, get some ropes and climb up there. Real quick, we have time for one more question. This person says, "Hello, I'm reaching out because last week I got a traffic ticket for speeding in a school zone. Thing is, I'm certain I was driving within the speed limit. Can you guide me on how to contest this ticket?"
Well, first of all, whenever you get a ticket, there's usually a set amount of time that you have to either pay the ticket or contest it. If you do contest it, you'll get a hearing date to go in front of a traffic court, essentially. And a lot of times people are just hoping the officer doesn't show up. Obviously, that's a roll of the dice. Sometimes it works, sometimes it doesn't.
Age-old strategy.
Yeah, but there are traffic ticket attorneys out there that you can hire for not a lot of money typically. Usually it's $100 or a couple $100 to represent you if you think it's important to do so, especially with that kind of ticket. There may be points on the license and other things you're trying to avoid, so it may be a good idea there.
Okay, that makes sense. Well, thank you guys for those questions. We have to take a quick break. If you want your questions answered, you can send those to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We will be right back with more of the DeWitt Law Review on WDBO 107.3 FM and 580 AM, Orlando's News and Talk.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400 basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. I'm Josh Fowler, filling in for John Busdecker, and I'm hanging out here with attorney Mo DeWitt of the DeWitt Law Firm. We are talking about legal issues in Florida and how they affect you, the lovely listener. If you have legal questions, you can send them to ask@DeWittLaw.com. That's ASK, ask@DeWittLaw.com. Or you can also give a phone call to the DeWitt Law Firm at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. And we'll be able to hopefully answer some of your questions for you right here on this lovely Sunday morning program.
And I should say that we also do have the voicemail line, 407-536-6737. So if you do have questions, it's just easier to phone them in, give us a call, 407-536-6737. And then we'll play it right here on the air and answer your question for you. Because sometimes, of course, if you do need legal help or legal advice, you're always welcome to call the office at 1-800-DeWitt-Law, like Josh said, or it's 1-800-339-4885. But I know a lot of times people just have one question, or they don't want a full consultation. They just have something that's maybe bothering them, or maybe they need a legal assistance down the road. They're trying to figure out the best direction to go. And that's what the show's here for. So feel free to leave us a voicemail if you need it. Again, that number is 407-536-6737.
Awesome. And then you get to hear yourself on the radio, possibly.
There you go.
That's always fun. All right. We did receive, I believe I mentioned last segment, multiple questions to ask@DeWittLaw.com.
Yeah, we got a lot to go through. I don't know if we'll get through them all today, but we're going to try.
I don't think we have enough time, but let's try to knock some out here. This one comes to us from Jimmy in Gibsonton. He doesn't care about being anonymous, he told me. He said, "Good day. My wife and I have been going through a rough patch for a while now, and it's looking like divorce is on the horizon. We've been married for 15 years, have 2 kids, and have a mortgage on the house. I also have a small business that I started before we got married, but it's grown substantially during our marriage. I'm worried about what will happen to all of these if we divorce. Could you possibly give me a general idea of how assets are divided in divorce and how child custody works?"
All right, so let's take it just like we would do in a divorce consult. So what's his name, Jimmy?
Jimmy.
Jimmy? So Jimmy's basically going to get a free divorce consult here.
All right, Jimmy.
So you've been married 15 years. So under the new statute, that's a moderate term marriage. So as far as alimony goes, you could be looking at up to 60% of the length of the marriage for the length of alimony. Now, the one thing we don't know is whether Jimmy has the ability to pay alimony and whether his wife has the ability, or excuse me, the need for alimony.
Right.
So in order to figure that out, we have to look at the incomes of each party and as well as their prior work history. So, for example, let's say Jimmy's wife, had been working all the way up until last year. They both made equal money, but then she decided she wanted to stay home with the kids, so she stopped working. Well, on paper, she may have a need for alimony, but most courts would probably look at that and say, okay, she's voluntarily unemployed, or in some cases voluntarily underemployed if maybe she went to part-time or something like that. So there may not be a need for alimony if they're both making similar incomes.
So if she's still capable of working perhaps a full-time job and making that income.
Right. She has the skills, training, and experience to go out and get a job making a decent income or making an income on the same level as Jimmy. So that's what the court's going to be looking at when they're determining whether one party is going to be entitled to alimony or not.
Right.
And that's obviously one of the most contentious things in any divorce case is going to be the alimony, because nobody wants to pay alimony. Even the nicest person in the world I've met who wants the fair and amicable divorce and maybe will agree to pay alimony, they still don't want to pay it. So that's one thing we're going to have to look at and determine whether alimony is going to be an issue in your case. Of course, you also have, two minor children here. We don't know the ages of the kids, but with any minor children or any minor child involved in a divorce, we're going to have to do what's called a parenting plan. And as part of that parenting plan, it's going to define each party's rights and responsibilities when it comes to that child. So we're going to go through things like first of all, what is the time sharing schedule? What commonly referred to as child custody in the state of Florida. So what does that schedule look like? When is mom going to have the kids? When is dad going to have the kids? How are the pickups and drop-offs going to be done? Where are they going to be done? What happens if one party is late? We're also going to go through and look at the holiday schedule. So what holidays are important to your family? Some families have a big Christmas Eve celebration, for example, while their families are more focused on Christmas Day. So you may have a situation where you're going to take a look at that, winter break from school, and maybe one parent has, from the first day of the break through, Christmas Eve at 10 p.m. and then the kids go to the other parent's house, and they sleep there and wake up Christmas morning at the other parent's house through the end of Christmas break. But that's going to rotate. So in even years, that's mom's schedule, and in odd years, that's dad's schedule. So it goes back and forth
to keep it fair.
To keep it fair and balanced, exactly. And we're going to look at things like if one parent has Christmas in one year, they probably won't have Thanksgiving, because those are typically the two big holidays for any family.
Right.
So we're going to try to rotate those big holidays. And then you can really get as custom as you want with it, again, depending on what's important to your family. So, Easter is very important to some people. Some people feel very strongly about their own birthdays as the parents, or, Mother's Day or Father's Day, or the kids' birthdays. Now, I've always said there's no child who's really complained about having two birthday parties. and for the most part, kids are at school on their birthday, of course, depending on their age.
Yeah, usually.
So, some parents feel very strongly that they want to have the child on their birthday. Others are okay with, the kid will probably be at school on their birthday anyway, so we'll throw a birthday party for them when we have them during the regular schedule, during the regular rotation.
On your weekend visits or whatever.
Right. Well, I mean, and typically, I should mention, a lot of people assume that, the norm is that, dad gets every other weekend. And while that may have been the case, 20 or 30 years ago, I really think most judges now have gone quite a bit of ways from that. And actually, under the new statute, there's a presumption for 50-50 or equal time sharing. So we really are outside that realm at this point.
Gotcha.
Where we're now starting with, hey, we want both parents to be involved in the child's life as much as possible. We're going to start with the presumption that they should both equally be involved in the child's life, unless there's a reason for them not to be. And usually those reasons have to be pretty serious and pretty substantial. Things like abuse, mental health issues, drug and alcohol addiction. Those are the types of things that the court's going to be looking at. not necessarily that, mom or dad gives the child peanut butter sandwiches and the other parent doesn't think that's healthy. And typically, that's not the type of thing that the court's going to want to get involved in. Now, you laugh, but I've had these cases before.
I'm sure some people get really into the minutia of that.
Well, first of all, it's an emotional time. It's a divorce, and it's your child. So I understand that. But you also have to remember the courts are dealing with thousands of cases, and a lot of times they're really seeing the worst of humanity. So, they want to kind of focus on the best interest of the child, the well-being of the child. And beyond that, these, like you said, the minutia is really more of individual parenting decisions. Now, obviously you can disagree with that. That may upset you. But you did decide to have a child with this person. And that's the ultimate reality of what's going to happen is you can't control every aspect of what the other parent does, whether you like it or not.
True.
So that's how we're going to deal with the two kids. Obviously, we need to know their ages a little bit more to kind of delve into the parenting plan more. Usually, I say when we have younger children, we want to do a more frequent back and forth because, being a day or two away from any parent for a 3-year-old is a much longer period of time than being away from either parent for a 10-year-old.
Yeah, or if you're 15, you can go, like a week or two at a time?
Yeah, usually at that point, you're probably doing, maybe a week on, week off. Again, every family's different. Every situation's different.
Co-parent, however works for you.
Right, and I should say that, the idea of the parenting plan is hopefully you can take the parenting plan, put it in a drawer somewhere, and never have to look at it.
Right.
Because you and the other parent are able to co-parent. But the parenting plan is there in the situation where you guys cannot agree or cannot co-parent. That's where it is going to control. And so if there's a disagreement, that's where you pull out the parenting plan and you look at it. And that's why you want to be as specific as possible in that parenting plan. Mm-hmm. And, just from experience, we've anticipated a lot of these issues that come up. And so that's why you really want more of an in-depth parenting plan. You don't want something that says we're going to agree later, because the problem is that document is to be used when you don't agree.
Yeah.
So if you do it where, we'll just agree to that later or leave that blank for now, you're going to end up back in court over and over and over again. And that's, first of all, not cheap. That adds up and can be expensive. It's also not healthy. I mean, living your life inside a courtroom, constantly arguing and constantly fighting is not good for you. It's not good for your children, because even though they're not supposed to know what's going on, it still seeps through, and they have ways of figuring things out.
Kids are smart.
Yeah, they can kind of figure out what's going on. So, you want to make sure that parenting plan is certainly as detailed as possible. Now, I know we only have a couple minutes here, so I'll try to get to the rest of the question. But, you guys have a house together. We kind of talked about this at the beginning of the show. Basically, this house was purchased during the marriage, I believe they said.
I believe so.
Yeah, so
they don't mention whether anyone wants to stay in it or not. They just say they're still paying a mortgage.
So we'll talk about both scenarios. So basically, the house is purchased during the marriage. Basically, anything that's purchased during the marriage is split 50-50. There's a few exceptions, but for the most part, it's split equally. And same with debts. Any debts that are acquired during the marriage are split equally as well. So, we look at the house. What's the fair market value for the house? What's owed on the house? And then we see what the equity is, essentially. Now, one party can buy the other party out by paying off, half of that equity and refinancing the home into their own name, or you can simply sell the home and split the proceeds. Now, obviously, the issue that arises a lot of times when one party buys the other party out of the home and you do the refinance is, well, what's the true value of the home, right? So,
right.
One party, may say it's $500,000. The other party says $550,000 because they're trying to get more money from that refinance. And so, this crazy real estate market, the prices can change quite often.
Very wildly.
Yeah, but a lot of times we may have to have appraisals done in order to determine that, if there's some disagreement on that. Of course, it depends how far apart, people are.
Yeah.
Sometimes we can just, convince people that it's a fair market value by looking at other comps in the area, pulling the recent sales and things like that. But it is a bit of a crazy real estate market, so we do have to kind of look at that aspect of it and see how things have changed. And sometimes from the now as interest rates are going up, maybe the house was worth more a year ago when your divorce started. Maybe it's not worth as much anymore because
True.
Depending on what price range it's in, there's not as many buyers because the interest rates are so much more now.
Right.
So those are all factors that we're going to have to consider. Now, the one that I'll touch on pretty quickly here, but could be a very important aspect of this divorce is the business. So just like any other asset, the business is a marital asset. It has a marital component to it. So it was started during the marriage, and it could have a marital value to it.
He says he started it before he was married, but it grew substantially during the marriage. Does that kind of change things, or?
Well, again, we can kind of follow the analysis. If it grew substantially during the marriage, it's, it probably didn't have much value prior to the marriage, I'm assuming. And so,
Right.
Unless and it's going to be nearly possible to do this, but let's say you bought a company, for instance, right?
Okay.
And you paid $100,000 for that company, and it was just on autopilot. You never had to put any marital efforts into it, and it just kind of grew passively. I don't know what kind of company that would be exactly, but
The best one.
right. Let's say that happened. There, you may have an argument that that's a non-marital business. But for most businesses where you're working there, you're putting marital efforts into that business, and the business appreciates during the marriage, it will probably have a marital component.
Okay.
Now, we do have to look at the type of the business, though, because there's what we call personal goodwill. So, if let's say I'm a plumber, and, it's just me, and I have a truck, and I have some stuff. But really, this is a job. Even though it's a business, this is my job, right?
Right.
So, and value that business isn't going to really have any value because the real value is me. It's my efforts that I'm bringing. So, really, what you're looking at when you're looking at a business is what could this be sold for on in the market, essentially. And a lot of times we have to bring in experts to kind of make that determination.
Yeah, I mean, I'm sure that's a little more complex than we could even get into here on the show.
Well, there's just a thousand different ways and 1,000 different types of businesses and different ways to value them. But maybe we'll do a whole show on it one day.
Yeah, maybe. Thank you, Jimmy, for your question. Again, if you'd like further advice, you can give us a call, 1-800-DeWitt Law. That's 1-800-DeWitt Law. Everyone listening, email us, ask@dewittlaw.com to get your questions on the air. We have to take a quick break. We'll be right back with more DeWitt Law Review on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Thank you all so much for joining us on this lovely Sunday. It's been nice hanging out and answering your questions. I'm Josh Fowler in for John Bustecker, and I'm here again with attorney Mo DeWitt of the DeWitt Law Firm. If you have legal questions that you'd like us to get to maybe next week, you can send them to ask@dewittlaw.com. That's ASK, ask@dewittlaw.com. And I believe we would just want to remind you real quick about the justcallmo.com Comedy Jam coming up in September out at Tuffy's in Sanford. I believe that's September 15th, correct?
Yeah, that's September 15th. And again, every dollar raised is going to a great charity, local charity here in town, the Yellow Brick Road Foundation, which you can learn more about them at ybrf.org if you like. But they're a great charity, so we've done this. This is going to be the third year now. Where we have a bunch of local comedians out. Great night of entertainment, just a lot of fun. And if you want to join us, you can get tickets at moecomedyjam.com. And tickets start for as little of a donation as $15, but you're certainly welcome to donate more. And again, every dollar goes to that charity.
Perfect. And it's a great cause, and it's going to be a good time. And I believe it's a Friday, so that's a nice night out kind of start to your weekend there.
Yeah, last year we got canceled because of the hurricane, and then we had to reschedule
That's
it.
right.
So I think it was on a Thursday last year, unfortunately. But this year we're back on a Friday, and it should be a great time.
Gonna be super fun. I intend to make it there myself.
Look forward to seeing you.
I'm looking forward to the party. We have, I believe, time for one more question if you're down for it. This comes to us from Sharon from the Villages. She says, "Hello. I was shopping at a grocery store when I slipped and fell on a wet floor with no warning sign. I've been having back pains ever since and had to take time off work. I'm considering filing a personal injury claim. Could you possibly explain the process to me and what sort of evidence I should start gathering?"
Sure. So, I mean, slip and fall cases can be tough if they're not handled properly. So, if you do find yourself in this situation where you slip and you're injured, it's always a good idea to file an incident report or alert the store so that an incident report can be done. Now, of course, if you're injured, you also want to seek medical treatment right away.
Right.
Where a lot of people get in trouble, especially us guys, is we get hurt and then we say, I'll be fine. And then that's the next day we can't move, or a week later, yeah, then we have to have surgery and all this kind of stuff. And of course, the insurance company is going to argue, well, you weren't injured here, you must have been injured somewhere later, and it just kind of opens up that Pandora's box of where else could have you been injured, or this wasn't related to this. So that's the most important thing, is if you are injured, let the store management know so that they can do an incident report. And then, of course, seek medical attention as soon as possible. Now, just because you slipped on liquid and hurt yourself doesn't necessarily mean that you have an injury case. In Florida here, basically, you have to show that the establishment either knew or should have known about that liquid on the ground.
Right.
And in grocery stores, people are picking things up, things spill, customers drop things. So that can be an issue depending on how long that substance was on the floor. And so that's why surveillance footage is very important in these types of cases, for both sides, really, is to see how long was that substance on the floor. And then, of course, you're going to look at things like, what was the store's policy? Were there employees who were walking right past the spill and did nothing to clean it up or put signage there? Did the employee themselves spill the liquid? If that happened, if the employee spilled something or caused the incident, that ultimately led to the injury, then you may still have a case even if it was only there for a few seconds. So the details of slip and fall cases can be very important. We're about to run out of time, I know, so I could talk about this for a half hour, but
it's
definitely
your favorite topic.
Well, not quite, but definitely give an attorney a call and walk through the situation with them so they can advise you whether you have a claim or not. But I would encourage you to act right away in speaking to an attorney, because claims don't get better with age, and we do have a fairly short statute of limitations here in Florida, which means if you miss that, your claim could forever be barred.
Fair enough. Thank you for answering that question in the limited time frame we had. Nice hanging out with you this morning.
Yeah, thank you for joining us and stepping in for John Bustecker, who couldn't be here this week. We certainly appreciate having you.
Someone's got to be the hero, right?
Yep, there you go.
Thank you all for listening to the DeWitt Law Review. We'll be back next Sunday at 10 a.m. talking about Florida's legal issues and how they affect you. Again, this has been the DeWitt Law Review on WDBO 107.3 FM and 580 AM.